All right. We are right at the top of the hour. Let's go ahead and kick this off. I appreciate you jumping on, spending about an hour with us to talk about the importance of policies and procedures with drug testing in your workplace, especially with all emerging and changing laws regarding marijuana, CBD. This is not a black and white conversation anymore. There's a lot of gray, and it is so unbelievably important for you to understand in your role as either a business owner or a management of an HR department how those rules and policies are changing, how they're evolving, so that you can overlap those into the right policy for your business. We're very fortunate here at ARCpoint to have partnered with DSCI, Mr. Bill Judge, as well as Nick Hartman, who are experts in this very thing. We've partnered on several of these webinars pertaining to various topics with drug testing policies and emerging state laws, marijuana, how the opiate crisis is affecting business today, and they've done a fantastic job for us. We look forward to continuing to do these types of presentations. There's just a couple things to keep in mind as well. Over the next couple months, we're going to start pushing out, for those of you that are regulated by DOT, the clearinghouse is coming. It is something that you don't want to ignore and something that you need to know about. So over the next several months, we'll be sharing content on social media within our email platform, as well as doing webinars about the new clearinghouse and what HR managers need to know, as well as frequently asked questions. So be on the lookout for those updates. Additionally, at the end of this presentation, you will learn different ways that you can improve your policy, as well as some tools that you can use. We will tell you about those and tell you how to get those, but also we'll message you after this. Finally, at the end of the presentation, we'll share the code for you to get credit with the Society of Human Resource Management ongoing educational credits. It is valid only for those that attend live. So thank you for taking the time to join and be a part of this discussion. Like I said a couple minutes ago, it really is an important discussion, and just the fact that you are willing to take an hour out of your day, which I'm sure there's lots of competing priorities, in order to learn about how to mitigate the risk for your organization, shows that you're compassionate, you care about the people that work for you and that you work for. So thank you for joining. We're very appreciative of you being here. With that, I'm going to turn it over to you, Nick.
All right. Thank you very much, John, and appreciate the ARCpoint Labs team for allowing us to join them again for a great presentation. And happy Wednesday to everybody. Thanks for joining us. And as John mentioned, taking time out of your precious day to get a little bit of information, and hopefully soak this up and be able to apply it to your workplace program. So thank you. My name is Nick Hartman. I'm the managing partner of Drug Screening Compliance Institute, or DSCI. Joining me is my co-founder, Bill Judge, the chief research director here at DSCI. Today, we're going to cover some critical information for employers as they work to navigate through the growing web of compliance with these new marijuana laws, past medical marijuana laws, of course, the opioid crisis, and other issues that impact today's workplace drug screening programs. As John mentioned, this presentation does qualify for one SHRM continuing education credit. For those that hang with us for the entire presentation, we'll provide that information at the close. Also, as a reminder, attendees will receive a copy of today's presentation in our post-event follow-ups with the code, of course, for those that are confirmed attendees. And lastly, if you have any questions as we go along, I'm sure there's going to be questions that relate to your specific situation. While we won't be able to cover it all, we certainly encourage you to ask your questions and submit them through the Zoom chat box, which we'll be monitoring throughout the presentation. And we reserve some time at the end to answer those questions. Okay, before we jump into the content, a quick legal disclaimer. Information we'll be presenting today, of course, is provided as information only, should not be taken as legal advice. We encourage you to consult your legal team prior to taking any action based on the information that we present today. All right. Our agenda for the day, we're going to do a recap of where we stand today with the laws and how they impact workplace screening programs. We are going to dive in on how your drug-free workplace policy should be updated and revised, how to appropriately do that, and of course, how to ensure your procedures are compliant and effectively manage the goals of your drug screening policy. We're going to recover the difference between state and marijuana statutes versus the actual regulations that are implemented and how that is important when it comes to your policy and procedures. And then we're going to discuss really the new golden ticket here is job descriptions, and we'll cover exactly why that is. But as the language of these laws evolve and further impacting workplace screening programs, job descriptions are going to be key in making sure that your program is successful in complying with those laws. And as I mentioned, we have some time reserved for some quick Q&A to make sure we answer all the questions that you guys have regarding this topic. All right, so you may know that it's become a very complex world for compliance out there. The legal landscape that brings requirements to employer screening programs has evolved even over the last decade, but even more recently at an incredible pace. I'll cover a few of these briefly, but we'll definitely get into more topic specifics. But everywhere starting at 1 o'clock here at the state compliance level, there's 22 states that have mandatory drug and alcohol screening laws for employers that wish to conduct drug testing. Those laws, some of those are very vague as to just making sure you use a laboratory, to incredibly complex, like Oklahoma, for example, that has pages upon pages of regulations of what employers need to follow when they conduct testing. Of course, we got marijuana issues, which will be a core focus of our presentation today. Medical marijuana laws, now legal marijuana laws that are, as I mentioned at the top, the language of those laws are starting to impact workplace drug and alcohol screening programs. We're going to cover briefly workers' comp opportunities, the financial opportunities for employers that do conduct drug and alcohol testing. We'll cover the 19 states that offer a claim defense based off of a positive drug test. That's really where employers should be focusing. The real money is on drug testing, and can really provide a great ROI on your drug testing program is utilizing those financial benefits to defeat workers' comp claims when those employees test positive for drugs or alcohol. We're going to cover briefly the ADA as it relates to marijuana and alcohol and testing for prescription drugs. Quick note that people try to leverage the ADA specifically as it relates to medical marijuana, but in actuality, since the ADA is a federal entity, it does not provide employee protections for state medical marijuana laws. It's since it's obviously illegal at a federal level, but we'll cover more on that a little bit later in the presentation. OSHA, of course, their rulemaking had kind of gone back and forth a little bit last year, but essentially as it stands today, the rule is that you make sure that you test anybody whose actions or inaction could have contributed to the accident, making sure you're not singling out anybody. Key agency decisions, court decisions, there's been several high-level court decisions been decided as it relates to marijuana and what rules apply, and whether an employer violated a state's medical marijuana law or disability discrimination law. We'll cover all the rest of that here soon as well. Unemployment, again, another great financial benefit for employers to utilize drug testing, drug and alcohol testing to defeat unemployment claims. Federal rules, of course, DOT, as John mentioned, there's a huge new change coming to the world of Department of Transportation regulations with the clearinghouse. As John also mentioned, this is not a time to put your head in the sand. Definitely need to pay attention, because it does impact any employer that employs a commercial motor vehicle or anybody that drives with a CDL. So lots of action steps that are being required both on the employer side, the driver side, and for any of your service providers. Of course, the National Labor Relations Board, or unions, quick note there that recent ruling does provide that a union-covered employee does have the right to have a union representative present at the time of any suspicionless testing or reasonable suspicion testing, if I can get that out. new rule that kind of was implemented. And of course, key court cases, we've kind of touched on those already. And state compliance. So as you can see, this is just kind of showing the landscape of compliance that continues to grow. I think we keep adding circles to this every time we present. So really, in the end of the day, it causes a bunch of confusion as to there's all these rules, what state rules apply, what do I need to know about my drug screening program, what can we do, what can't we do, how do I interpret the language of these laws, how do we apply it from a policy perspective, how do we apply the language from a procedural perspective to make sure that you're compliant. So hopefully today we can alleviate a lot of the confusion, some misinformation, and hopefully give you the tools that you need to be successful. Of course, we always caution everybody that taking actions without having the information that you need, of course, can be very, very costly. The cost of non-compliance is something that we track here at DSCI. Because it's important. It's dollars that are coming out of employers' bottom line if a mistake happens or they unfortunately do the wrong thing. So we've tracked these for several years now and find payouts being ranging between $30,000 up to $2 million, including some supervisors and managers that are personally held financially responsible in some of these instances. Everything from disability discrimination suits, wrongful termination claims, settlements, jury awards, and consent decrees. Of course, all these we'll cover here in a little moment, but again, the landmines that exist out there are very prevalent. All these agencies are certainly acting on these, and employers are paying the price when they do not comply, understand, and follow the rules. So as I mentioned, here's where we are today. 33 states and Washington, D.C. currently authorize the medical use of marijuana. There are 11 states in Washington, D.C. that allow the medical and adult personal use of marijuana. And as it stands today, 18 states that allow some form of medical use of cannabidiol, non-hemp, cannabidiol oil, tinctures, etc. As you can see, Idaho and Nebraska, the only two states that don't have some form of marijuana law. And who knows when or how soon that actually might change as we head into November here. This is where more laws tend to come up and change. So definitely been a lot of activity. And also in those states that currently have cannabidiol permissions are also looking into adopting medical marijuana laws. So something that we keep track of here at DSCI and share with the team at ARCpoint to make sure you guys stay up to date on the legal landscape and as these changes are adopted. We'll also get a little bit more detail on this, but there are 22 states, as I mentioned, where private employers must follow if they wish to conduct drug and alcohol testing. The states are highlighted here that have drug testing limitations by statute, or whether it's related to the state's medical marijuana law, or even personal use limitations and other drug testing limitations, whether it be by court case or by statute. So we'll cover more of these, but again, this map continues to get complicated as we continue to track the issues as new rules come up, new language of the laws start to evolve, and ever more so start impacting the workplace screening arena. And then finally, I'll talk about the 19 states. I mentioned this earlier. This is really where the money is in drug testing, the ROI that you can find in your drug testing program, all the money you're spending screening your employees, paying your service providers to manage your drug testing program. You can use drug and alcohol testing in the results in these 19 states to exercise a rebuttable presumption of intoxication claim defense to defeat a workers' comp claim. If you need more information on this or how those, what the specific rules are that you must follow in order to qualify for those benefits, the team at ARCpoint can happily provide that information. But again, this is a golden opportunity for you to leverage an ROI on your drug testing program if you're not doing so already. Okay, with that, I'm going to turn it over to my colleague, Bill Judge, and we are going to get into the differences between policies and procedures and what you need to know on how do you go to craft these policies, update your policies, implement procedures, and then we'll cover job descriptions shortly after. Bill?
Thank you, sir. Much appreciated. And as John mentioned, we appreciate you folks taking time out to listen to us for a little while here today. One of the things that we've been focused on lately based on our research, and that's all we do is research these issues. And one of the things that's come to light for us and been made very clear is the significant difference between policy and procedure. It's certainly one thing to have a well-written, well-crafted policy, but it's another thing completely to have the appropriate procedures in place for you to be able to have a complete drug testing program. And that's kind of how we look at this. We don't look at it as your policy. We look at it as your program as a whole. So it starts with your policy. And in some instances, you may have state requirements to follow, as Nick showed you just a moment ago, the 22 states that mandate how you do drug testing, if you're going to do drug testing at all in their states. And some of those states, like Minnesota and Oklahoma and Iowa and others, tell you exactly what has to be in the policy, in general terms, okay? But as you sort through the policy or the statutes and the regulations and the court cases, it becomes very clear that you need a lot of other stuff. And that other stuff doesn't necessarily have to be in the policy. It needs to be in a procedural fashion somehow. Your policy is really just your company philosophy. What do you want? Who do you want to test? When do you want to test them? How do you want to, and so on. But it's really just a policy statement. We hear all of the time people say to us, well, we want a zero tolerance policy. Okay, fine. What does that mean? Technically, from a scientific and medical perspective, there is no such thing as zero tolerance. But if what you're talking about is not permitting any, quote, illegal substance or illegally used substances in your workplace, okay, that's a whole different ballgame. If you're talking about who it is you think needs to be in a drug testing program, that's a whole other thing. But policy is really your company's philosophy. And as I mentioned, you really need to determine, and sometimes it takes a little while to sit back and think about these issues. Who is it you really want to test? What do you want to test them for? You've got a lot of choices out there in terms of what you want to test for. Are you going to limit yourself to the, quote, illegal substances that federal rules typically cover? Or are you going to cover other things? Are you going to use, I'm talking about the difference between a 5-panel and a 7-panel and a 10-panel, and you got to think these things through. Where are you going to test? And when I talk about where you're going to test, I'm not talking about Charlotte versus Denver. I'm talking about, are you going to test on site using an instant test device? Are you going to test only in a laboratory? You need to think about what's best for your particular situation. Probably the most important item to think through is when. When are you going to test people? Are you going to do pre-employment testing? Are you going to do random testing? Please be aware that there are a number of states that either prohibit or limit random testing, as well as 2 cities, Boulder, Colorado, and San Francisco. You got to pay attention to the rules that apply to your testing program. And again, how are you going to test? Instant, laboratory, how are you going to do it? Are you going to have a split specimen opportunity? This all goes into the whole post-test rights issue. You're going to let folks have independent analysis if they test positive? Are you going to have an MRO? If a state doesn't require you to have an MRO, should you have an MRO? I can tell you as an attorney that's been doing this for almost 35 years, my view is that if you don't have the MRO do the analysis, you don't have a test. You have to have a medical review officer. I don't know how to make that any more plain. And then you have to think through, of course, the consequences. You're going to fire people? In some states, you can't. You can't fire somebody in Minnesota the first time they test positive. Are you going to give people an opportunity to go to counseling? Okay, well, what does that mean? Is it counseling? Is it treatment? What is it? Are you going to do follow-up testing if you allowed someone to have an opportunity to go to counseling? What about the difference between someone who voluntarily comes forward and says they need help versus somebody who tests positive? You better be careful about the person who voluntarily comes forward, because they may have either state disability discrimination rights or ADA protections. So you got to think all of these things through. And then typically what we find with folks with the procedure side of things is people just ask us to tell them what to do. Well, it's not our job to tell you what to do. That's your job. We can put the information in front of you, which is exactly what we're happy to do, but you have to make the choices. We believe that if we give you the information that applies to your situation, the answer in terms of what to do will be pretty obvious. So, you got to stop and think, because this stuff will make you stop and think. Okay, so, yes, it's a philosophical question. Should the policy include everything, like the kitchen sink, or should it just be vague? You know, you'll find that some of you who have talked to some of your attorneys will say to you, oh, we want to keep this stuff very vague. I'm not of that school. I believe you need to be as clear as you can be so that people know what they're expected to do. Do you do a few paragraphs, or, you know, Nick and I have seen policies as big as 50 or more pages. Well, I can guarantee you one thing. If you give somebody a policy, an employee a policy that's 50 pages long, they're not going to read it. So you need to think through how you want to approach this. Should you, in your policy, if it's applicable, should you recite the language of the statute word for word, or use your own words? Well, I clerked in the Illinois Appellate Court, and I clerked for a judge who said to me one time in a not so nice tone, if the legislature has already chosen the words, why would you substitute yours? Okay, what does that tell you? It tells you if the statute describes for you what random testing is, then use their description, because that's what you're going to be held accountable to. So if the language exists through a statute or a court case or a regulation, use the language that exists. Okay? Okay, our view is to keep your policies short and sweet. Make them very, very clear. Make them as understandable as possible. What does the company expect the employee to do? That way, not only will your employees understand, but your managers and your supervisors will understand as well. Please keep out all extraneous words. What does that mean? That means words that don't have any application to further the intent of the policy. Just keep it short and sweet. Separate procedures from policy. Again, in the idea of keeping the policy short, if it's a procedural item, please, you know, keep that for your manager's guide and how to deal with procedures. And we'll show you that in just a second here. There are significant differences state by state. As I mentioned, I think before, states like Oklahoma and Iowa and Minnesota, they'll tell you exactly what your policy has to consist of. So they'll have in there that the policy must contain things like you know, who you're going to test and when you're going to test, and the fact, like Minnesota, here's one of the key things in Minnesota for those of you in Minnesota, you've got to make sure that in your policy it states that employees and applicants have a right to refuse the test. You need that statement in there. You also have to make sure that you pay attention to some of the procedural aspects, like on the right-hand column there, subdivision 2 deals with the notice issues and the fact that employers must provide notice, written notice, by the way, of the drug test policy, and also provide a post. You have to post notice or summary of the fact that you have adopted a drug testing policy. So you have to pay attention to these differences between policies and procedures and cover them all. This is here just because I like the picture. No, what Nick and I hear all the time, and I'm sure John and his folks there too, what they hear all the time is people just want to be told what to do. No, we're not going to tell you what to do. We're going to give you all the great information and you're going to know what to do. Part of that is our approach to the use of checklists. We are checklist crazy here, because we believe that if we can take the procedural aspects of your program, the requirements of the statutes and regulations that deal with what do you do once you've got your policy done. You see the first bullet point up there, number 1 says, okay, this happened. This is applicable only after you've got your policy. Once you've got your policy in place, now here's a checklist for how to implement that policy, how to live with that policy. And what we do, the way we approach things is our procedures go into what amounts to a checklist so that we're sure you're going to do everything that's detailed in not just the statute, the regulations, but also court cases. If court cases have been issued and it describes for you how to post notice or the size of the notice that has to be posted or something like that, then we're going to make sure you have that in a checklist so you don't miss it. Because it's the procedural side of things that really cause most of the lawsuits. And so that's what we're trying to focus your attention on. One of the things that people often confuse as we talk to them is they'll say to us, well, you know, we did our policy and we followed the statute. And that's it. It's like, well, wait a second. What about the regulations and, you know, agency decisions and court cases and, you know, everything else? The law consists of not just the statute. The law in your state where you operate, where you want that policy and those procedures to work, the law consists of the statute, the regulations, agency decisions, court decisions, and court decisions at 3 different levels, at the trial level, the appellate level, and ultimately the Supreme Court level. You have to make certain that your policy contains all of that stuff, because if it doesn't, you may be doing something wrong, and you might get sued and lose because you didn't realize that the statute is different than the regulations, or that the statute is different than a court interpretation of what that statute means. So you got to pay attention to everything that's here. I know it sounds horrible, doesn't it? But that's why we're here to help you. Okay, what am I talking about in terms of statute versus regulations? Well, let's just take a North Carolina example here. If you look on the left-hand side, that's the North Carolina mandatory statute. Now, understand, Nick told you there's 22 mandatory states in the country. And what that means is that if you're going to do drug testing in North Carolina, you can only do it according to North Carolina's rules. Okay. So here's just a small portion of the North Carolina statute for drug testing, and it's talking about the requirement of retesting. Every person who's tested must, you see that word at the top there, shall have a right to retest a confirmed positive sample. Okay, and what it says down below is that the person that has the positive test has to pay for all, quote, reasonable expenses related to that retest, like chain of custody, the retest of a positive, and so forth. Well, okay, that's great. Now, if you stopped at the statute, only at the statute, and looked at that, you'd think, all right, we're going to send them a bill or charge them everything related to retesting that sample, right? Well, not so fast. If you look at the right-hand side of that chart, these are the regulations that interpret what reasonable expenses mean. And you see that it means the actual cost of the retest charged by the lab, fees assessed by the approved laboratory for the expenses associated with the retest, and a maximum of, oh my God, $15 for the person tested's expenses, if any, to comply with chain of custody procedures related to the retest, okay? And the amount of $15 for the expenses described here in that regulation shall be deemed to be the reasonable amount. Okay, it's $15. That's it. That's all that they can be charged. So if you didn't pay attention to the regulations, or for that matter, didn't know the regulations existed, you'd be missing the boat and probably overcharging them. You got to pay attention to both the statute and the regulations. Here's another example from North Carolina. The statute doesn't say anything about notice, nothing whatsoever. But the regulations put the burden on you to not only have notice at the time the person is being tested, but then also another notice, both of them written, by the way, if in fact the individual is positive. So within 30 days, from the time the result is mailed or otherwise delivered to the person tested, the examiner must give notice to the person tested in writing of any positive result of the exam, and then of the examinee or the person tested's rights and responsibilities. Those rights are, for instance, the right to have the specimen retested. So if all you did was read the statute, you wouldn't realize that the regulations require you to provide two different types of notices. Do you folks all have forms for this? Do you know what you're supposed to say in those notices? Well, if not, give John a call. John's going to kill me for telling people to call him. Get in touch with ARCpoint, and they'll help you figure it out, because we're going to help them figure it out. Here's one other example, and it's from Oklahoma. One of my favorites. I usually tell people in Oklahoma, you know, I tell them that the rules are so complicated. What I suggest to them is that they move. But the statute says, by definition, drug means, and you can see the list there: amphetamines, cannabinoids, cocaine, phencyclidine, hallucinogens, and goes on and on and on and on and on, right? The regulations, however, limit that. The regulations say, okay, you can do drug testing of a controlled substance, but you can only test for Schedule 1, 2, or 3 substances. What does that mean? Well, under Controlled Substances Act, usually federal or state, there are 5 schedules. Schedule 1, those include drugs that have absolutely no medical purposes and are highly addictive. And then, of course, Schedule 2, those are drugs that are highly addictive but have some medical use, so they can be prescribed and so on. Schedule 4, 5, you know, they have medical uses and less addictive. That's how it works. But if you are testing and you don't know what substances you're testing for, you're just, you know, leaving it up to a laboratory or somebody else, they may not realize that Oklahoma doesn't allow you to test for Schedule 4 or 5 drugs. And there was a case recently where somebody tested positive for phenobarbital. Okay, well, that's a barbiturate, and you can see on the left-hand side, that's listed there as something you can test for, right? Well, yeah, but phenobarbital is a Schedule 4 drug. She got fired, she got a lawyer, and she won. So you've got to be careful to make sure you know what these regulations say and how they interpret the statutes. You also, you also got to take a look and see if the courts have jumped into the discussion here, because here in Iowa, Iowa's Code Section 730.5 specifically defines when an employer can do a post-accident test, and it lists it there for you on the left-hand side. Section 730.58F indicates that you can do a post-accident drug test to investigate an accident in the workplace that results in an injury a Chapter 88 reportable or damage to property that exceeds $1,000. Only under those circumstances can you do a post-accident drug test in Iowa. And if you look down below there, Chapter 88.6 defines for you what the Chapter 88 includes. Okay, that's great. Now, if you look on the right-hand side, in the case in 2012, Skipton versus S&J Tube, that involved a situation where an employee was being treated for carpal tunnel. A new HR manager comes in and she says she's got to go get her treatment for carpal tunnel that day. And the manager says, well, why aren't we drug testing her? Well, she'd been getting this treatment for now a year. Okay, so the manager said, well, we're going to drug test her. Well, she became irate and she refused. And so she was fired. Well, she goes and gets a lawyer, and the court says in the case, well, wait a second, soft tissue kinds of injuries are not considered accidents. And what they did is they looked at to the Supreme Court of Iowa's definition of an accident, which is a sudden event or change occurring without intent or volition through carelessness, unawareness, ignorance, or a combination of causes, and I love this, and producing an unfortunate result. And then the court went on to say a cumulative injury is not a sudden event or change, and we conclude it is not an accidental injury. Carpal tunnel, other soft tissue type injuries are not considered accidents under the definition under the Iowa statute, which permits you to do a drug test. That case cost that employer $40,000 because they didn't know that was not an accident. So if you're operating in Iowa, please understand what the definition of an accident is, or more to the point, what it isn't. All right, now, finally, I want to make sure that as all of this evolves, you understand how important job descriptions are becoming. With the shove that the court issues are getting from medical marijuana and from personal use of marijuana, this is becoming a hot issue. Does your company have detailed job descriptions for each of your for each of your jobs? If you don't, you have to have. When is the time for your job descriptions? When was the last reviewed? I'm sorry, can't read the screen. When were your job descriptions last reviewed? Dust them off. You're going to need to change them. Are you prepared to defend your stance on a job position function? Are you ready to defend that position is safety sensitive? You better be, because you're going to be asked to. Okay, everything's changing. Everything is evolving quickly under these new marijuana issues. We have a number of changes that have occurred just recently. For instance, City of New York passed an ordinance that'll take effect in 2020, and it prohibits now all pre-employment testing for marijuana, unless you're in certain positions. And those positions are safety sensitive. In Nevada, the new law that just passed and will take effect the beginning of 2020. Nevada is the first state that prohibits pre-employment testing of marijuana unless you're in a safety sensitive position. In Nevada, by the way, the difference between New York City and Nevada, New York City, the labor commissioner there is going to decide what is in fact safety sensitive. In Nevada, the employer will decide what's safety sensitive. But please understand, your job descriptions are going to be critical in those instances to defending your judgment about whether or not those positions truly are safety sensitive. Illinois has a new law going into effect. It permits personal or adult use of marijuana, and that's going to start January 1st. We've been getting inundated from folks that operate out of Illinois trying to figure out what they can and can't do. And the reason is that there's a great deal of confusion that results from a provision that was tacked on to that law at the very end. And essentially what the law does is this: the new adult use of marijuana law says employers can have zero tolerance policies. Employers can drug test. Employers can discipline people, including terminating them for testing positive. However, big however, employers cannot discriminate against someone for off-premises or use during non-duty time of a lawful product. And when they say lawful, the statute defines that as lawful by state law. Well, come January 1st, marijuana use is going to be lawful. Now, there's a little discussed provision, which I think kind of changes the whole issue here. It's subparagraph B and the second sentence of subparagraph B. I hate to get too lawyerly on you. And that says that the whole law, this restriction, this anti-discrimination law doesn't even apply if the lawful product used impairs performance. All right. So there's a great debate going on now in Illinois among the legal scholars as to what that word impairs means, and the fact that we cannot determine from a test alone that someone's impaired. We have people who I have great respect for who are writing articles saying that come January 1st in Illinois, employers can only do reasonable suspicion testing from now on. I disagree, because I believe that the focus should be on the off-duty legal product and whether or not the product impairs, not whether or not the person was impaired at the time of the test. We're not sure how that's all going to focus out. But anyway, it's incredibly important, as you can see, that New York, Nevada, even New Jersey, that has a new law that limits employer testing as well. Those, except in the safety-sensitive positions, you've got to make sure that your job descriptions are clearly indicating what is safety-sensitive and what isn't, and why they're safety-sensitive positions. Now, don't do what people are trying to tell us, okay? We get calls all the time, and people are saying, well, everybody is safety-sensitive here. Well, you may think so, but you're going to have to prove it, okay? So, you know, these guys in the upper left-hand corner, they're clearly safety-sensitive. The folks that are in the middle here, middle picture here, I'm not sure I would call them safety sensitive, except what about the fact that, you know, the yoga instructor is helping somebody and she's, you know, misapplying the technique, and she, you know, causes some back pain to somebody. Is that say? I don't know. Anyway, now in the lower right-hand corner, I'm going to call that guy safety sensitive, and I'm going to question what it is he's doing there, okay? And whether or not he should be doing that. But you're going to have to sit back and take a clear look at every single job position you have and determine safety sensitive, non-safety sensitive, and write it up. Where do you get the idea for how to write these things up? Well, one source is the ADA. You know, the definition of an essential function. Here's how they define an essential function under the ADA. It says evidence of whether a particular function is essential includes, but it's not limited to, the employer's judgment as to which functions are essential, and written job descriptions prepared before advertising or interviewing the applicant for the job. Written job descriptions. I'm not going to go through all the rest of these because we don't have time. I want you questions in. But anyway, that's important, job descriptions. So you can look to the ADA, but also make sure you're paying attention to medical marijuana laws according to the state's rules and how things might be defined there as well. Okay, one last point. This is a case out of Massachusetts. Some of you may be aware of, cited in 2017. It's the Barbudo decision. And in this case, the court ruled in favor of an employee and allowed her case to continue against her employer. Her employer had argued that they couldn't accommodate this person because federal law would be violated if they allowed her to use medical marijuana and continued to employ her. The court disagreed. The court said that doesn't apply here. Whether or not you hire somebody who might be committing a crime, that doesn't have any effect on you. But some other interesting aspects of it is that the court also said that the employee's use of marijuana is not, under the circumstances, unreasonable. You know, what was fascinating in the case, the court literally said marijuana should be treated as any other prescribed medication. Fascinating. But the court went on to say, but that doesn't necessarily mean the employee will ultimately prevail, because the employer may be able to offer evidence to show that the employee's use of marijuana cannot be reasonably accommodated. Why not? Well, maybe your job description for her position shows that she's in a safety-sensitive job. And the employer may offer evidence to show the employee's use of marijuana would pose a safety risk or impair her performance. Okay? So job descriptions are becoming more and more critical as proof in cases that they cannot accommodate an employee's use of marijuana. The court went on. I'm not going to read all the stuff on the left-hand side, but the court said basically that the employee's employer should initiate an interactive process with the employee to see if they can reasonably accommodate her medical condition, and go from there. Everybody's a little bit crazy over the whole medical marijuana issue. Let me tell you something, folks. Other than in Nevada and New York, none of these limiting statutes or ordinances say that you can't test. What they say is you can't discriminate. All right. Well, that means that you should continue testing for marijuana, and then if there is a positive, you should enter into the interactive process, the discussion with the person, to see if you can accommodate their condition for the job to which they're applying or the job that they're in. And then you have evidence or proof that you can't accommodate them. Then you've done what you're supposed to under the law. But simply saying we're not going to test is silly, because if you're in a safety-sensitive industry, that's just not going to work. How are you going to defend that when somebody gets hurt or hurts someone else and they're positive for marijuana? You're in trouble. But you can take steps to enter into an interactive process with that person and ultimately conclude, we can't accommodate you because you're trying to drive a bus. We're not going to let you smoke marijuana and drive a bus. You know, the ADA and the interactive process is designed to reflect the fact that, you know what, we just don't let blind people drive school buses here. It doesn't make sense. But what employers aren't doing and aren't grasping is the fact that they need to enter into the interactive process and understand what that means in order to adequately determine if they can accommodate somebody or not. Okay, I'm done. I'm going to turn back over to Nick, and he's going to give you some thoughts to terminate this.
Thanks, Bill. Great word choice there. A ton of information, obviously, and unfortunately, we only have the hour here, so we can't cover it all. But as it was mentioned in the chat, if anybody that has any questions, feel free to contact your local ARCpoint representative. We definitely can get you access to more information here. Some takeaway for employers: look at the legal landscape's changing dramatically. You got to stay on top of it. There's some action steps you can take to proactively prepare yourself to comply with these laws and be in a good position to enforce an effective drug-free workplace. So first and foremost, clearly understand the language of the laws as it relates to either state-specific court or agency decisions, et cetera, that apply to your program in each of the states where you operate. Gone are the days where you have a blanket national drug and alcohol testing policy or nationwide drug testing policy. These laws, as Bill and I have kind of covered here, vary greatly by state. So you need to make sure you clearly understand that and consider that as you go to write your policy and then your procedures. Create and implement and routinely review that policy. Make sure that it's up to date, as again, this information changes very rapidly. Unfortunately, I would probably say over half of the time we deal with a employer coming to us wanting to revise their policy, it has been at least 5 years since that policy had been dusted off, taken out of the drawer, and taken a look at. That is not a good policy to have, because it's certainly going to be a liability, because most likely the law has changed since then. You should design and implement sound processes and procedures that complement the specific language within your policy. This would remove any guessing or potential mistakes for your supervisors and managers that are tasked to enforce these policies during the heat of the moment. Takes the guessing away. Be sure to document comprehensive job descriptions for each role within your company. As Bill mentioned, some of these laws, and increasingly more so, are including some form of safety-sensitive carve-out, an exception to the law so long as the job meets the safety-sensitive requirement that it could exempt you from those employment limitations. But again, as Bill mentioned, you should be sure that you're ready to prepare that in court if it should be challenged. I meant defend that in court. Be prepared to engage in an active process, as Bill mentioned, with an applicant or an employee to determine if their underlying medical condition or disability can be reasonably accommodated. This is, again, one of the biggest things that are impacting employers now from a disability discrimination claims and lawsuits, is because they simply didn't take that one last action step to evaluate the underlying medical condition, not just because the person failed for medical marijuana and had a positive drug test, but they're legitimately using medical marijuana for an underlying medical condition. Be sure you're prepared to enter into that interactive process to assess whether or not that employer applicant can conduct that job function. Educate your employees on the dangers of impacts of drug and alcohol use. Encourage your employees to seek help. If they have a substance abuse problem, refer them to an SAP or give them information to your employee assistance program so they can go seek the help that they need. Very, very important to train your managers and supervisors on the details, not only with your company's drug-free workplace policy, but they need to clearly understand the rules and laws that apply to them. What is their role as the gatekeepers and enforcers of your workplace drug and alcohol policy, and the tools that they need to go about doing so. And also how to recognize, making sure your managers and supervisors know how to recognize, document, and confidently act on signs and symptoms of impairment. So if they see, smell, or hear somebody that could potentially be under the influence of drugs or alcohol in the workplace, they need to be confident that they can act and know exactly what to do, so they're not, buddy or afraid to take action, but they know exactly what the steps they need to go through to make sure whether or not they need to pull that person from their duties and get them tested under reasonable suspicion circumstances, and then most importantly, clearly document exactly what their observations were, maybe get another supervisor to sign off on those observations, what steps they took to get the person tested, whether the person refused or not, or complied, and then of course any post-test information that they need to document. So again, all of this is going to be beneficial for you as the employer, for them as the manager or supervisor, if anything goes sideways and gets challenged in the court of law. All right, with that, I'll turn it back over to the team at ARCpoint.
All right, Nick, Bill, thank you so much for such good information. If anybody else is with me, I think our heads are spinning a little bit by how complicated this can be. And so one of the things that we do as ARCpoint Labs, in many cases we're known as drug testing, but we also are becoming more and more known as local industry experts that can help you navigate your specific state laws and how those specific state laws affect what you can and can't do with your drug testing policy, random program management, and supervisor training programs. And so a couple of the resources that we highlight on this slide But we have just a variety of these that are available to you, several of which are free of charge. One is an employer guide to marijuana and CBD. This is a very informative guide that summarizes the state laws specifically applicable to you and how they affect your policy, what you can and can't do with marijuana and CBD. We can provide your state laws to you. So while these are available publicly, we have these just available turnkey for you as well. We provide those for free. Just reach out to us and we'll email those over to you and have you talk with an industry expert in your state. We provide substance abuse professionals. We have a network of substance abuse professionals that if you decide that you want to provide that, or if you're in a regulated industry that requires that, we can help you identify those professionals. And listen, if you just want help developing your policy so that you know it's going to be compliant based on the most up-to-date state laws, we have policy development wizards that will ask you specific questions about your random program management, the frequency of testing, whom you wish to test, and then the state that you reside in. And we can actually, we can even put your logo on that policy for you, and you know that you have an updated policy. And once again, in some cases, that's something that can be provided free of charge. In other cases, for a very small fee, we can put that together. We have signs and symptoms training programs that are very turnkey. Once again, we provide this in some cases free of charge. In other cases, we actually will do a live signs and symptoms training program for your supervisors. But in this program, you get a supervisor training video. There's checklists. There's guides for your supervisors to use in identifying signs and symptoms in the workplace. We even provide you a certificate of completion to provide to your supervisors once they've watched the video and completed all the tasks that are outlined. So it's a very, very turnkey program for you to be able to implement in your business to mitigate your risk in the areas that were discussed today. Once again, everybody, our goals are very much to educate HR managers so they can feel comfortable that they have the most up-to-date and accurate policies and procedures available in the market. If you have information, if you have a desire to follow up, email us at info@arcpointlabs.com or go to arcpointlabs.com/contact. And we will reach out to you and we'll get an industry expert in your local market to sit down live, have a face-to-face meeting with you to talk about your concerns and help you navigate to a good solution. I think we are good. The chat window looks like it's open. Thank you for those of you that filled out the webinar poll. If you haven't, we're going to leave this up for a couple more minutes. So you can go ahead and give us feedback on whether or not this was valuable, some ideas on future topics that we'd like to cover, and then just general survey of how comfortable you feel about your compliance program that you currently have in place. But Nick, Bill, once again, thank you so much for putting this together. Jamie, the team on the marketing team, our local industry experts that have joined the call as well, our network of ARCpoint owners out in your local market. Thank you for joining and becoming a part of this process as well. And you know where to find us, info@arcpointlabs.com. If you have any questions, we'd love to help you out. Thanks for your time, guys. Enjoy the rest of your day.